Hello everyone, this is Blue Record Studios. I'm Yoon Choi, and for this episode I will be bringing up a topic of Black Lives Matter and what happened in court. Derek Chauvin, the police officer who put his knee on George Floyd's neck, will be going to court. What possible arguments would be made in the court? Let us unfold the incident step by step. Hope you enjoy it. Here's a similar case with George Floyd that occurred on November 12, 1984. A black man named Dethorne Graham got involved in a run-in with the police in Charlotte, North Carolina. We refer to this case as the orange juice incident, since all Graham was hoping for was to get a bottle of the juice to counteract the insulin reaction within his body. Graham was a diabetic. Graham, with the help of the ride from his friend Barry, was able to reach a convenience store, but he figured the waiting line was too long. So, he quickly got out of the store and searched for another place where he could get the juice. At that site, we had a Charlotte City police officer, Miss Connor, who was sitting in a patrol car in the vicinity of the convenience store. He became suspicious of Graham and Barry, and decided to force an investigative stop of the two black men. It was talked through in the testimony that one of the officers rolled Graham over on the sidewalk and cuffed his hands tightly behind his back. Here's what the police officer replied when Barry pled to get some sugar for Graham since he was diabetic. "I've seen a lot of people with sugar diabetes that never acted like this. Ain't nothing wrong with the MF but drunk. Lock the SOB up." Graham passed out. When Graham gained his consciousness, he tried showing his diabetic to call to the officers, but one of the officers was recalled to tell Graham to shut up and shove his face down against the car. It was found that Graham has done nothing suspicious in the convenience store, and the officers released him from confinement. However, Graham was severely injured from the interaction. A broken foot, cuts on his wrists, a bruised forehead, and an injured shoulder were the multiple injuries that he sustained. This was how Graham decided to file a suit in the district court, charging that Connor and the other officers used excessive force in violation of rights secured to him under the 14th Amendment to the United States Constitution. An accusation has been made. So what does Dethorne's lawyer have to prove in order to win the trial? First, they needed to show that the police officers had acted maliciously for the purpose of causing harm. The standard which needs careful attention is on proving that the officer did so with malice in their heart. What's another point of argument? The Fourth Amendment includes the word reasonable. In law, it is said that we evaluate the word reasonableness with objectivity. So this means that you look at the who, what, when, where, but not why. Well, why not why? It's because the component of why can only be discovered from the defendant's words, which leads the losing of some validity. So we want to see what a reasonable officer would do within the presented circumstances. Well, it was a very wise decision for the side of Graham to stick on with the word reasonableness because the concept of reasonableness had hundreds of years of precedence. However, we must recall how this case was the first one to take the standard of reasonableness to bear on police actions. Let's hear some of the argument the lawyer of the police officers made, and from this we are able to catch some flaws.
Well, One justice, Thurgood Marshall, the lone African-American on the court, comes in and just asks,
what reason was there for handcuffing a diabetic in a coma?
Well, at the time, the officers didn't know that he was a diabetic in a coma.
What was he doing that was so violent that he had to be handcuffed?
You have to go back one step even before that. Officer Connor saw a petitioner act in a very suspicious and unusual manner. Hurry into a convenience store. Well, it wasn't clear. He saw him hurry into a convenience store.
Well, what did he do that was violent?
Excuse me?
What did he do that was violent?
Mr. Berry's
anybody?
Testimony, as petitioner's own witness, said that petitioner was throwing his hands around, that Berry had asked for Officer Connor's help.
What was he doing? I'm talking about before they put the handcuffs on him. What was he doing before they tried to put the handcuffs on him?
He was acting in a very bizarre manner. He ran out of the car, circled around it twice, and then sat down. The district court...
Was that threatening anybody? Did he strike anybody?
Well, the officers didn't have to wait until he was...
Did he strike anybody?
I don't believe the record indicates that he struck anybody.
Did he threaten to strike anybody?
He was acting in an unpredictable and potentially dangerous manner.
Can you answer? Did he threaten to strike anybody?
He did not overtly threaten to strike anyone.
Did he have a weapon of any kind?
The record doesn't indicate, I don't believe.
The record didn't show he had a weapon of any kind?
That's correct, but the record...
Why was he handcuffed?
The record shows that he was properly stopped as a suspect for a criminal investigation, that he was acting suspiciously, that he was acting in a bizarre manner. Indeed, even after he was handcuffed and the officers went to put him in the car, the undisputed record shows that he was vigorously fighting and kicking.
Well, shouldn't a diabetic object to being arrested rather than given treatment?
He wasn't arrested. He was never arrested.
Why was he handcuffed?
He was handcuffed because the officers were concerned that he was a criminal suspect. He was acting in a very unusual and erratic way. He was throwing his hands around. Indeed, the district court stated from the record that he was handcuffed in part to protect himself as well as the officers and others.
To protect himself.
That's the district court summarized the record as indicating that. That's correct. Now,
may I differ with that conclusion?
We can clearly hear that there was no reasonable reason for him to be handcuffed, just like what the judge says over here. Like, shouldn't a diabetic patient be treated instead of being handcuffed? Then what would the bulk of the argument be? Well, the trial would start shifting its focus on discussing what a reasonable officer would do at the time. So we would have to establish what a reasonable officer is. The judges held the hands of Graham at the trial in the Supreme Court, but when it was taken back down to the trial court level for another trial, the jury decided to favor the police officer. Yes, Mr. Graham lost. Now, get ready for the miserable aftermath. The trial of Graham eventually became a negative precedent for other trials of black people, such as the case of Tamir Rice, a 16-year-old boy who got shot by the police officers while he was playing with his toy gun at a playground.
Instructed to ask what a reasonable police officer would do in this particular situation.
The jury in New York City has refused to indict yet another white police officer said to have killed an unarmed black man.
This city killed my son.
Philanda Castile, reasonable.
Are you kidding me right now? We're not evolving as a civilization. We're devolving. We're going back down to 1969. Damn!
It actually prevented the victims from getting relief and instead protected the cops. So let me introduce what guidance was included in the jury instructions. So what the jury members were told to think about when they were deciding the ruling of the trial. It is outlined that the judges must judge the reasonableness of a particular use of force from the perspective of a reasonable officer on the scene. So this was basically an idea that originated from the fact that police officers are often forced to make split-second decisions about the amount of force necessary in a particular situation. So we would be asking questions like, did the officer feel threatened, or did that officer have a reasonable fear at that moment? Critics claim that this is a loaded question. As we can see from this jury instruction, it seems as if the court has determined to only view the scene from the officer's point of view without taking into considerations any of the perspectives of the victimized people. Well, what do you think is the standard of allowing us to prosecute these officers? Whether or not the police officer used force due to his or her prediction of the subject possessing a gun, when it is found the police officer was wrong, then the officer should be convicted. It's basically a debate on whether we should let go 10 criminals or get one innocent to be shot in the street like an animal. Which side would you choose? All the officers who were involved in killing George Floyd or threatening Graham weren't completely willing to do the act at the time. This was another claim made in the court. But when we look at the Minneapolis Police Department's procedure and policy manual, there's a small category about duty to intervene in the use of the force section. So this means that an officer has a sworn duty to intervene if they see another officer essentially doing something that they think is unreasonable. So today I presented to you the case of Dethorne Graham. A case when the Supreme Court decided Black lives don't matter. What comes up in your mind when you hear the ruling of the court? It's very shocking how, like a person myself who is not a legal person, can basically understand the argument the defense made was not reasonable nor logical. Why does a place like the Supreme Court, where most justice should be seen, decides to remain silent when it is aware of its own fallacy and discrimination? It's something essential for us to think about. So we will end it here today. Thank you for listening. Court will be back soon
with another interesting
and worthy topic.